Welcome, I'm Patricia Gonzalez, an employment lawyer with Parley McLaws. In my last two videos, we talked about employment agreements and the concept of wrongful dismissal. Today, I want to talk more closely about notice of termination, and in doing so, I will cover the following three topics. First is the statutory notice period, the second is common law notice periods, and lastly, the contractual notice periods. As you may recall, an employer who wants to terminate the employment of an employee on a without cause basis will generally have an obligation to provide the employee with sufficient notice that the employment agreement will come to an end at a certain date. The amount of notice that the employer provides to an employee is commonly referred to as the notice period or notice. The amount of notice that an employee is entitled will either depend on the common law or the specific terms of the employee's employment agreement. Now, Part 2, Division 8 of the Employment Standards Code of Alberta sets down the minimum amount of notice of termination that an employer must give to an employee. These are commonly referred to as the statutory minimums, and they can range from 1 week to a maximum of 8 weeks, depending on the years that the employee has worked with the employer. But the statutory minimums are exactly that, the minimum. It is the floor but not the ceiling when it comes to how much notice an employee is entitled to. What few employers and employees know is that Section 3 of the Employment Standard Code provides that any common law right or a custom that places an obligation or a duty on an employer that is greater than what is set out in the Employment Standard Code remains intact. As a result, an employee is not limited to the statutory minimums and can rely on the common law notice periods as long as his or her employment agreement does not have a valid termination provision. Now, the common law notice periods are for the most part more generous than the statutory minimums. So how do the courts determine the common law notice period that an employee may be entitled to? When determining an employee's common law notice period, the court will conduct an individual analysis of the employee's individual circumstances through a framework referred to as the Bardell factors, which are as follows. 1. They will look at the employee's age. Second, they will look at the employee's length of service. Third, they will look at the employee's character of employment, which refers to the duties and the tasks of the employee's position within the employer's organization, and this often goes beyond just looking at the employee's title. And lastly, the courts will look at the availability of similar employment. There is a common misconception that there is a rule of thumb of 1 month per year of service. However, the courts have been very clear that such rule of thumb does not exist. In my experience, notice periods can range from as little as 1 week per year of service to many months per year of service, depending on the Bardell factors. As previously mentioned, an employer and employee can decide to opt out of the common law notice periods and come to an agreement as to how much notice period an employee will be entitled to if the employer decides to terminate the employment agreement on a without cause basis. Although this area of law is nuanced, generally, to be enforceable, the contractual notice period must at least meet the following 4 requirements. First, the employment agreement must be valid in accordance with the principles of contract law. Second, it must be clear and unambiguous. Third, it must comply with the Employment Standards Code in that it cannot provide an employee with notice of termination that is less than the statutory minimums. And fourth, the employee must clearly waive his or her common law rights. As stated before, if you are considering terminating an employee or are an employee that has been terminated, I highly recommend that you speak to an employment lawyer to make sure that you are providing or have received sufficient notice of termination. Once again, thank you for joining me and learning more about employment law.